everyone, and thanks for clicking on my video today. All right, so the US government attempted to take some viral videos off of the internet, arguing through the court system that these videos should not be public. Ultimately, the courts disagreed with them and refused to restrict the publication of these videos. And I want to talk about this story because it shows us how these decisions around what the public gets to see are actually made. And it also shows us how the public interest can play a large role in how these decisions are made. Okay, so here's some context. A lawsuit was filed in May 2025, and I'm going to refer to my notes so that I say the names of the organizations correctly. So it was the American Council of Learned Societies, or ACLS, the American Historical Association, or AHA, and the Modern Language Association, or the MLA. So these three nonprofit organizations filed a lawsuit against the US government, but more specifically, they filed it against the National Endowment for the Humanities, or NEH, as well as the United States DOJ service, along with a couple of high-ranking officials attached to both of those entities. As this case was going through the legal process, there were some depositions recorded and ultimately made public by the AHA, so the American Historical Association. And the depositions were from Nate Kavanaugh, Justin Fox, Michael McDonald, and Adam Wolfson. And so the AHA made these depositions public. They posted them to their YouTube channel. And after that, they went viral due to the information that was revealed in them. And then they began to spread widely across the internet, and it was even covered in the news. I want to go through the lawsuit behind the DOJ depositions and explore how we got to that viral moment, and also why the court ultimately ruled not to restrict their publication. So let's begin by going over what NEH is and why it is important. So I'm going to be reading from the lawsuit that was filed by the nonprofit organizations. And I've gone through and clipped the parts that I want to read. And as you can see, I've made these little annotations to help keep me on track. So what is the NEH? So they say, over the last 6 decades, with bipartisan support from Congress and administrations of both political parties, NEH has grown to become the largest and most prestigious funder of advanced humanities research in the United States. So that's essentially what it is. But what else? So it says, since its founding, NEH has awarded over $6 billion in grants to museums, historic sites, colleges, universities, K-12 teaching, libraries, public television and radio stations, research institutions, and independent scholars. Scores of organizations and individuals rely on NEH to fund important projects and research that could not be accomplished without NEH's support. Congress's funding of NEH and its programs has continued to this day. In March 2025, Congress appropriated an additional $207 million to NEH to fund its activities, the vast majority of which NEH must use on its grant programs. Congress established the National Endowment for the Humanities to broadly fund research, scholarly work, and the advancement and promotion of the humanities. Finding that, quote, the arts and the humanities belong to all people of the United States, end quote, Congress created the National Endowment for Humanities and its sister agency, the National Endowment for the Arts, in 1965 as part of the National Foundation on the Arts and Humanities Act of 1965. In establishing the NEH, Congress found that, quote, it is necessary and appropriate for the federal government to complement, assist, and add to programs for the advancement of the humanities and the arts by local, state, regional, and private agencies and their organizations. Congress believed that the federal government has a key role in helping create and sustain not only a climate encouraging freedom of thought, imagination, and inquiry, but also the material conditions facilitating the release of this creative talent. Accordingly, Congress established NEH to provide funding for organizations and individuals involved in research, publication of scholarly works, and promotion of the humanities. Congress viewed this directive as a broad one, meant to fund a wide range of projects and not to promote a singular viewpoint, and to fund traditionally underrepresented recipients. To that end, in creating NEH, Congress included several provisions aimed at protecting the agency from political influence. For example, Congress has prohibited federal agencies and employees from, quote, exercising any direction, supervision, or control over the policy, determination, personnel, or curriculum, close quote, of any grantee organization. So that's a little bit more context on what the NEH is, a little bit of a historical background on how this even came to be. So now let's go through the events that transpired that caused this lawsuit to be brought in the first place. What exactly happened? Okay, so on March 13th, 2025, NEH Chair Shelley Lowe was directed by the White House to resign her position. Shortly thereafter, teams from DOJ began appearing at the NEH offices. According to accounts of former and current NEH staff, in March 2025, defendants Kavanaugh and Fox of DOJ met with NEH leadership to discuss DOJ's plans for NEH's future. Defendants Kavanaugh and Fox have reportedly been deployed to multiple small agencies, in most cases to swiftly carry out mass terminations of staff programs and grants. In addition to NEH, defendants Kavanaugh and or Fox reportedly have been deployed to the National Labor Relations Board, the Inter-American Foundation, the Millennium Challenge Corporation, the U.S. Institute for Peace, and the African Development Foundation. On April 1st, 2025, NEH staff members reportedly were informed that DOJ sought reductions in NEH staff by 70 to 80% and, quote, what could amount to a cancellation of all grants made under the Biden administration that have not been fully paid out, close quote. Acting Chair Michael McDonald told senior staff that DOJ wants to claw back $175 million in grant money that has not yet been dispersed. And remember, earlier we saw that in 2025, they were granted an additional $207 million. So now they're saying they want to, quote unquote, claw back $175 million. That's what apparently Michael McDonald reported. According to accounts of former or current NEH employees, while at NEH, Kavanaugh and Fox were provided one or more lists of open NEH grants, and Kavanaugh and Fox repeatedly asserted that canceling at least $175 million in grant money was imperative. According to accounts of former or current NEH employees, very shortly after receiving the list of open NEH grants on April 2nd, Kavanaugh and Fox emailed nearly 1,500 grantees on the list, informing the grantees that their grants were being terminated, including nearly all grants issued during the Biden administration. According to former or current NEH employees, Kavanaugh and Fox did not process the grant terminations through NEH's grant management system as required by internal agency policies. So they are arguing that not only did they kind of swoop in, Kavanaugh and Fox, not only did they kind of swoop in and just start making unilateral decisions about where the money was going to be going and to some of these grantees, they were also not even following the internal agency policies, according to them. The emails received by NEH grantees did not come from an NEH server or email address, but from, I decided to redact this just in case, but you can see it's a different email. And it says it's a non-governmental email account. The emails attached a grant termination letter purportedly signed by acting director of NEH, Michael McDonald. The termination letters were not hand-signed by McDonald or digitally signed with a verifiable digital signature. Instead, the signature on the termination letters was simply typed by someone as S. Michael McDonald. So they are saying that when they eventually did send these terminations out, they made it seem like the acting director, Michael McDonald, was aware of these terminations and that he was signing off on them. But they're arguing that they just typed in there Michael McDonald, and it was not a verifiable digital thing. There was no way to really determine if this really came from Michael McDonald or not, but it was presenting itself as though it did come from Michael McDonald. On information and belief, the termination letters to all grantees sent on April 2nd were nearly identical and lacked any individualized analysis or discussion of each terminated grant. So they're basically saying they mass sent out these emails. They all said the same thing, regardless of their situation. On April 3rd, 2025, 145 NEH staff members, making up 80% of the staff, were reportedly placed on administrative leave. According to accounts of former or current NEH employees, this included 100% of the staff of the Office of Publications, the Office of Native and Indigenous Affairs Division, and the Office of Data and Evaluation. On Information and Belief, it included more than 75% of the staff of the Office of Digital Humanities Division, the Office of Communications, and the Division of Education Programs. According to accounts of former or current NEH employees, Kavanaugh and Fox pressured NEH employees to execute a reduction in force as quickly as possible. On April 9th, 2025, NEH staff received a notice alerting them to an upcoming multi-step approach to restructuring that promised to include a RIF, or reduction in force. The notice stated, this restructuring will consolidate administrative and programmatic offices to enhance efficiency and streamline functions. As a result, the agency will be forced to reduce the total number of positions, essentially letting go a lot of the staff. The very next day, many NEH staff received RIF notifications that they would be terminated as of June 10th, 2025. On Information and Belief, approximately 70 to 80% of NEH staff received a RIF notification. So basically, 70 to 80% of the staff was being removed. So not only were they going in and trying to quote unquote claw back a whole bunch of money that was already allocated to go to certain grantees for research, for museums, for all the things that we just read about, they're saying not only were they cutting all that or trying to cancel what had already been apparently allocated, they were also letting go a lot of the actual staff of the NEH. According to accounts of former or current NEH employees, as a result of the termination of staff and grants, NEH has effectively eliminated or nearly eliminated entire divisions and programs, including but not limited to the Office of Digital Humanities, the Office of Federal/State Partnerships, the Office of Data and Evaluation, the Office of Native and Indigenous Affairs, the Office of Outreach, and the Office of Partnerships and Strategic Initiatives. As a result of defendants' actions, NEH is no longer able to effectuate its statutorily required duties. It has terminated nearly all of its current grants and most of its future programs, despite having nearly $400 million in funding for programs over the last 2 years, including $192 million it received for grant programs in March 2025. NEH has terminated the staff necessary to undertake the vigorous peer review process necessary to effectively award new grants. NEH has eliminated most of the staff required to oversee any grant it does award. So they're saying all of this reduction in staff is making it, they're not going to be able to work effectively at the NEH. There's a lot of money sitting with the NEH that has to be, because Congress allocated the money already, it has to be spent. And they're just saying that this is, ultimately, this is problematic for many reasons. Now let's go through the specific legal claims that are being made in the lawsuit. It says the Trump administration's dismantling of NEH is unlawful many times over. Most fundamentally, the Constitution grants Congress, not the president, the power to create and prescribe the duties of federal agencies. And Congress maintains the exclusive power of the purse in directing how federal funds must be spent. The president cannot unilaterally shut down an agency that Congress has created, nor may an agency refuse to spend funds that Congress has appropriated. Such unilateral executive action not only violates the constitutional separation of powers, but it also violates the Impoundment Control Act of 1974, which sets strict limits on the executive branch's ability to delay spending appropriated funds. So essentially, they're saying there's multiple things going on here that are not right. Number one, the president cannot make unilateral decisions about federal agencies, the president nor the executive branch. And DOGE is connected to, or was connected to, at least at that moment, the executive branch. So basically, they're saying the executive branch does not have the ability to make these unilateral decisions about federal agencies, especially when it comes to how federal agencies spend money. Only Congress is supposed to be able to do that. And once Congress has passed a budget for that year, and they've appropriated certain funds to certain things, that cannot be changed. That is pretty much set in stone until they vote again on the budget. Defendants' actions in eliminating programs and divisions, mass firing staff, and refusing to spend appropriations are also arbitrary and capricious under the Administrative Procedure Act. The actions are arbitrary and capricious in every way. That an agency action can be arbitrary and capricious. Okay, they really love that saying. Defendants provided no reasoned explanation for their actions. They relied on factors that Congress did not permit them to rely on. They changed long-standing agency positions without acknowledging the change, and they utterly failed to consider the reliance interests of thousands of NEH grantees that have long relied on NEH. Worst yet, all of these actions were taken or directed by DOGE, a body not created or authorized by statute. DOGE has no lawful authority to carry out the work of another agency, let alone dismantle it. The Supreme Court has made clear that federal agencies have no power to do anything unless given that power by Congress, and DOGE has been given none. Congress also provided for a process under which grant applications generally must be reviewed by NEH's National Council on the Humanities before being approved and issued by the agency. The council itself is made up of the chairperson and 26 private citizens who are recognized for their broad knowledge of, expertise in, or commitment to the humanities, and who are appointed to staggered 6-year terms, ensuring appointment across presidential administrations. The chairperson shall not approve or disapprove any financial support application until the chairperson has received the recommendation of the council on such application. In the 2024 Appropriations Act, Congress appropriated $207 million to NEH, of which $192 million shall be available for support of activities in the humanities pursuant to this section. As such, $192 million was designated for grants, loans, contracts, and other assistance to further the enumerated purposes set forth under this act. So basically saying at least $192 million had to be used, had to be available to support the humanities. On March 15th, Congress enacted a continuing resolution that reappropriated all of the funds appropriated to NEH under the 2024 Act, with the same breakdown on how the money must be spent. NEH thus received an additional $207 million that it must spend, including an additional $192 million that it must spend on grants and other assistive programs under this act. So the legal claims essentially break down into separations of power, the procedural processes of our government, aka how our government is supposed to run, and the authority of the DOGE entity and whether they were even allowed to go into this federal agency and make the unilateral decisions that they made. Okay, so that's essentially the legal claims, but why does any of this matter? Like, what impact does this have on society? Well, why don't we read the lawsuit and see what they have to say about that? They say, plaintiffs, their members, and the community at large are injured by NEH's decisions. Plaintiffs, their members, and the broader public have long relied on NEH grants to fund deserving projects in the humanities. The Trump administration's wholesale dismantling of the agency, termination of nearly all previously approved grants, and cancellation of numerous programs moving forward has caused and continues to cause plaintiffs and their members serious irreparable harm. The recent actions at NEH harm plaintiffs and their members in other ways beyond the loss of grants and future grant opportunities. Without a functioning NEH, there is no central body to fund the work that consortia, campuses, and individuals do to conduct research in the humanities, to improve teaching in the humanities, and to make humanities programming accessible to the public. NEH has played a role in countless advances in the humanities since it was founded, including thousands of books and articles made possible by research grants. NEH has more broadly supported key digital infrastructure projects that have benefited the public in various ways. NEH has been an influential source of funding for the software and tools that support and facilitate high-quality research and public access work. NEH's funding investments have been central to the formation and implementation of descriptive practices that make research materials findable and usable, such as the World Historical Gazetteer, which is an index of historical place names, or Period O, which is a gazetteer of historical, art historical, and archaeological time periods. So essentially, if the NEH is harmed, then nonprofit organizations will be harmed, and then ultimately society will be harmed, because the NEH provides critical funding to these nonprofit organizations, and without a strong NEH, many of these nonprofit organizations will suffer. Okay, so how do the depositions come into play and why do they matter? Well, the depositions were part of the discovery process in this case, and they were a matter of public interest because the information revealed in them showed us how our government is utilizing the funds that are ultimately coming from us, the public. But let's go through the ruling and see why the court ultimately decided not to restrict the publication of these videos and ultimately allowed them to remain public on the AHA's YouTube channel. Okay, so this is the ruling, and I've already gone through and marked the parts that I want to focus on. So it says, after transmitting the videos to chambers, plaintiffs published the video recordings online, posting the full, non-confidential versions of the 4 depositions on YouTube and making those same materials available on the websites of the American Council of Learned Societies and the Modern Language Association. After they were posted, the videos and excerpts created and circulated by third parties who are not parties to this lawsuit spread widely across the internet. The videos were cited in numerous news stories about the role of Doge in the termination of NEH grants. The government sent a letter to the court dated March 10th, 2026, in which it stated that the dissemination of the videos had resulted in harassment of Justin Fox and Nate Kavanaugh. It asked the court to enter a protective order to restrict their further dissemination by plaintiffs. In a subsequent letter dated May 13, 2026, the government advised that the risks it had previously identified had, in its view, escalated. It represented that the videos had circulated widely across social media and news platforms, and that at least one witness had been subject to significant harassment, including reported death threats. So they said when these videos, the government was saying when these videos hit and they started going viral, Justin and Nate were, receiving harassment, and they don't say who was getting the death threats, but they said at least one witness started to receive death threats, which is, that's not okay. Finally, the government speculates that individuals inclined to engage in harassment may be more likely to watch videos than to read written transcripts that are equally available on the public docket. So they had transcripts available of these depositions, and the government was saying, okay, people are not going to read these transcripts to the same degree that they will watch these videos. The videos are much easier to access, especially if it's put on YouTube. And so the government was saying people who want to harass are more likely to watch a video than read the transcripts. That, and the court says, that is speculation, and the court cannot assume it to be true. Nor can the court assume that a person motivated to express hostility toward the government's position in this litigation by engaging in uncivil or offensive conduct towards the officials involved would be deterred from doing so simply because plaintiffs were prohibited from reposting the video on websites devoted to discussing this case and informing the public about its progress. The harms the government identifies arise not from plaintiffs' conduct, but from independent third-party actors who accessed and redistributed the videos. Rule 26C relief directed solely at plaintiffs does not meaningfully address that source of harm. At bottom, the government has not shown that the relief it seeks is capable of addressing the harm it identifies. The videos have already been widely disseminated across multiple platforms, including YouTube, X, TikTok, Instagram, and Reddit. where they have been shared, reposted, and viewed by at least hundreds of thousands of users, resulting in near instantaneous and effectively permanent global distribution. This is a predictable consequence of dissemination in the modern digital environment, where content can be copied, redistributed, and indefinitely preserved beyond the control of any single actor. Given this reality, a protective order directed solely at plaintiffs would not meaningfully limit further dissemination or mitigate the government's asserted harms. So essentially saying it's already out there now, it's going to be extremely difficult to pull these videos off and make it so that third-party actors can't have access to it, make it so that these videos cannot be disseminated on the internet. And by targeting the plaintiffs and saying, okay, you specifically can't have these videos on YouTube, is not going to meaningfully change the fact that they're already out there and they're already being copied and shared and all of that worldwide. And they're saying that the relief that the government is seeking under this specific rule doesn't really address the harm that they are identifying, the harm that they're saying is happening. The relief under this rule wouldn't really address that issue. In sum, because the defendants have not demonstrated a particularized harm, have not overcome the strong public interest in dissemination of information concerning official conduct, and have not shown that the requested order would effectively mitigate the asserted injuries, they have failed to establish good cause under Rule 26C. So this is ultimately why the court decided not to restrict the publication of these videos. And today you can go to the American Historical Association's YouTube channel, and these videos are still up. So for me, this story is really about access to information and who ultimately has the power to control what the public is allowed to see. It also shows us what factors into these decisions. When the public largely engages with a story like this one, where they're sharing it and they're liking it and they are creating clips and disseminating it all over the place and having deep discussions about the information involved wherever they are on the internet, we see that public interest can sometimes outweigh efforts to keep things private. If you made it all the way to the end of this video, thank you so much. I really appreciate you, and I will catch you in the next one.